Hi folks, I'm Greg McLawson, the Affidavit of Support lawyer. My law practice focuses on enforcing the USCIS Form I-864 Affidavit of Support. I help low-income green card holders bring federal lawsuits to enforce their right to financial support under the I-864 Affidavit of Support. And I've been answering a lot of questions about the Uniting with Ukraine program, which does not involve the I-864, but rather the I-134 Affidavit of Support. One question I've been getting a lot is whether sponsors under the Uniting with Ukraine program have to repay the cost of medical care that's provided to the beneficiary. So if you sponsor somebody for Uniting with Ukraine and they come over here and have medical bills, are you as a sponsor on the hook? The answer is no in my assessment, and I'll explain why. So we have two different contracts, two different documents here, the I-864 and the I-134 form. As I've explained in other videos, the I-134 form is the old version of the Affidavit of Support. This has been used in immigration law for decades, and it predates legislation in 1996 that created binding affidavits of support, the I-864, that's used in family-sponsored immigration cases. That's not what we're talking about here. But even for binding affidavits of support, the I-864 form, in those cases, the government can recoup means-tested public benefits from sponsors. However, even under the binding affidavit of support, which again is not used in the Uniting with Ukraine program, even that binding form does not have a broad liability for medical cares. So even under the scary version of the affidavit of support, if the sponsored immigrant has general medical bills, goes into a hospital, and has tens of thousands of dollars of emergency medical procedures performed on them, even in the scary version of the affidavit of support, the sponsor is not responsible for paying back general medical bills. But the I-134 form isn't enforceable at all. And in fact, the fact that it's unenforceable is why Congress revisited this whole situation in 1996 and said, hey, we want to change this and create binding contracts in family-sponsored cases. But before that, before 1996, we had the old I-134 form. And there are plenty of cases in the federal system where a sponsored immigrant tried to enforce the I-134 form and was told, no, the I-134 is not enforceable. So as a sponsor in the Uniting with Ukraine program, you will see in the instructions that there are a list of things that you can put on the form as to what support you are going to be providing. It's technically a parolee, but the person benefiting from your sponsorship. And that can include facilitating their access to medical care. But if that person ends up in a situation where they have medical expenses, there's just no legal basis for the hospital or the federal government or a state government to come after you as the sponsor and waive that I-134 form and say, hey, the sponsor's on the hook. Because even if you put on that form that you are going to facilitate access to medical care, it's, again, not a binding contract. And a hospital can't use the fact that you submitted this form to the government as any sort of hook to go after the sponsor for liability. So bottom line, as a sponsor in the Uniting with Ukraine program, there is, in my assessment, no liability for medical care that's provided to the intending immigrant. And that includes, by the way, if the person ends up signing up for Medicaid or other state-sponsored medical benefits. For complicated reasons, they probably don't necessarily have the ability to do that, but even if they do, the sponsor should not be on the hook for the cost of those benefits. I hope this is helpful. I hope this alleviates some concern from folks who are considering signing up for the program. If you have questions, feel free to drop them in the comments. I'm happy to answer them to the best of my abilities. Have a good weekend, everyone.